Welcome back to It's Your Law. I'm George Curtis, and my guest is longtime friend, Waupaca attorney Steve Hansen, who has really provided a great deal of service to the people, the litigants in the state of Wisconsin, primarily as a mediator. Now, about 10 years ago, I think you were indicating that the legislature passed the law providing for alternate dispute resolution, and that included more than just mediations, didn't it, Steve?
Sure. There were other concepts that were involved, but it was interesting in that most judges in our area mandate mediation before you're going to go to trial. And what has been interesting is that when lawyers know they have to do this, oftentimes and the defense lawyer will get together and say, you know, we're going to spend a lot of money. Why don't we take a couple depositions? Why don't I share with you all of the information that I have relative to the claim, to include wage loss, medical bills, other items of expense, and then we'll see if we can get this done sooner than later. And it's remarkable. I remember one year I did keep track, and 98% of the cases that I mediated that year, and it was over 300, actually ended up being settled. Not necessarily on the day of the mediation, but within a week or two after that.
You and I love jury trials. It's a little bit the theater, the excitement of having the lead in the class play every week in a different play and that sort of thing. But to the litigants, it's not a game. They are having something at stake. They are certain that they are correct. You've never had a client, and I haven't had a client ever that didn't think he or she was 100% it right. But in litigation, it costs money on both sides, and somebody loses. There's something about the way Steve Hansen and other good mediators operate that nobody has to really lose. Could you explain that?
Well, I mean, when I look at a file, I spend a lot of time evaluating all facets of it, from the liability to the damage claims. And I normally come up with a range. But you and I know that it's impossible to predict what a jury will do in any given case. It depends on where you are, who is the judge, and most importantly, usually the testimony of the parties involved, and especially the injured person. And I've had a lot of experiences here in this office where I've looked at you and said, you know, George, I'm not sure your client's going to make the best witness. And so there are subtle things that go on during the course of mediation, and you and I have a propensity to tell people what we think, recognizing that the only basis that we can do that is that, you know, you've been around just a little longer than I have, and we have a lot of experience and gray hair and a sense of humor too. I think that's important.
How, Steve, does a mediation work? Now, as a matter of fact, we're having one here today at our office. You came down from Waupaca. There's going to be a very able defense lawyer coming over from the Nash firm in Manitowoc. My clients are already here getting prepared. How is it going to work?
Well, the first thing that I do is sit down with you and your clients and with the defense lawyer and kind of review the aspects of the case that need to be reviewed. That is, how did the accident happen? This is an auto accident. What were the plaintiff's pre-existing conditions? How much were the medical bills? Was there a wage loss? And sometimes one of the most important aspects is the subrogation component of a case. That is to say, are there insurance companies out there that have paid medical bills that want a portion of the settlement? And so we oftentimes get letters, or you have talked to that person, the lawyer handling the subrogation claim, or I have, and oftentimes we try to get them to compromise, which it can be very helpful in an overall settlement. Once we have this little get-together, which may last anywhere from 2 to 12 minutes, then I will stay in the room with you and your clients, and we'll talk over certain phases of the case, and I'll ask you what your expectations are and how you have evaluated the case, and then we'll come up with a number to take to the insurance company that would be your starting point. That is to say, well, we'll go and make a demand of $30,000 or $35,000, and then I'll go talk to the insurance company lawyer, and he'll tell me why the case isn't worth $3,000, and then we'll see during the course of the afternoon, and this case that we do today shouldn't last an hour and a half, and maybe we can come to a point where both sides are not happy but would be willing to settle the case to save a lot of time and money.
And of course, in my room, you come back after your visit with a defense lawyer and says, well, I'm not prejudging this, but the defense lawyer says you have this weakness,
Sure.
and this weakness, and he doesn't think your client's going to make a very good witness. And then, of course, we take that into consideration, especially if you think it has merit. You're not asked to judge the case, but sometimes my clients ask you for your opinion.
That's right, and one of your clients a couple weeks ago told me that he was the Italian stallion, and I told you if this guy gets on the witness stand and starts talking about that, that your case is going to go out the window. But anyway, you know, one thing that I think is important is that if you can get everybody to relax and you show them that, you know, this isn't the courtroom, they're not on trial, we're here to help them, we're here to help the other side, I mean, I am, to see if we can't get this thing over with, because oftentimes I think people think that everything that glitters is gold, and that isn't necessarily the case.
Well, I'll tell you, it is helpful from many standpoints for my clients. First of all, the clients are a part of the process. They get a chance to tell a stranger their point of view as to what their damages are and how the accident really happened. And when they feel a part of the process, that's half the reason they're in litigation. To have a chance to tell their story and have an honest person test their credibility. That's valuable to me. And the other one, I think, is that it saves money. And money is awfully scarce these days. It's always been scarce, but I think more so now. And as a matter of fact, let's take our second break right now, Stephen. When we come back, I want you to discuss the advantages to the litigants on both sides, starting with money, if you can settle their case today.
Sure.
We'll be right back. The ideal of American justice is an equal, level playing field, rich or poor. One way of doing it is with a contingent fee. If you're an individual, but you have a gripe or a conflict with a big corporation, a big insurance company, or even the government, if you can get an attorney who is willing to take your case to court on a contingency, no fees unless you win, then you have a chance to live the American dream of equal justice. The test of our system isn't whether or not it's fair to General Motors or President Nixon or President Kennedy or President Clinton. It's whether it's fair to you, an individual citizen. Our system isn't perfect, but it's the best in the country, thanks to the contingent fee. I'm George Curtis.